Hello, and we are back. And as promised, today we'll be discussing the Todd and Julie Chrisley's appeal that they filed, but we're also going to take a look at the indictment that led to their trial and conviction. Let's have a discussion surrounding all those issues so we could have an appreciation as it relates to why they were convicted, why they were sentenced to the amount of years that they got. And so we could appreciate a little of what transpired in the trial and the grounds for the appeal, the issues that are ripe before the district court. To that end, this is Let Get Legit LLC. Please note, people, this is not legal advice. It is my sunny Caribbean opinion on the legal twists to topics on social media, on reality TV, television, and just life's events in general. Please support my channel. And to all those new subscribers, all 20 of you, I see you. Thank you so much. Thank you, thank you, thank you. Much appreciated. As usual, here is our disclaimer. Copyrighted materials, if any, is being used in this broadcast. Please note that it's for educational purposes only. And if you believe we went beyond the fair use, please contact us, email us so we could amend and address our violation if you feel as though we have. As usual, please like, comment, share, and subscribe to my channel. Now let's get into it. The Chrisley's knows best, and I'm sure a lot of you familiar with this family. And as per People's Magazine, Todd and Julie are the married stars of the eponymous reality series Chrisley's Knows Best. The magazine further stated that the show premiered on USA Network in 2014 and is entering part 2 of its 9th season, which is expected to begin later this year. So, after nearly 3 weeks of trial, which began on May 16, 2023, Todd and Julie Chrisley were found guilty by a jury of 12 counts of bank and wire fraud and tax evasion and conspiracy charges as well. They were accused of submitting false documents when applying for rental property and loans. The couple were cleared of their state tax evasion charge in Georgia in October 2019, but continued to face federal charges for allegedly evading federal tax. They were sentenced on November 21st, 2022, just last year. So in a press release, U.S. Attorney Ryan K. Buchanan stated, over the course of a decade, the Chrisley's defrauded financial institutions and the federal government through tax evasion and other fraudulent means in an effort to minimize their tax liability, but project an image of wealth, said James E. Dorsey, Special Agent in Charge, IRS Criminal Investigation, Atlanta Field Office. He says, and I quote, this sentencing serves notice that no matter a person's celebrity status, there are severe consequences for defrauding the American tax system. The Chrisley's failed to file tax return or pay any taxes for the 2013, 2014, 2015, and 2016 tax years. As a part of the tax evasion scheme, Tarantino was convicted of filing 2 false corporate tax returns for the loan out company, which falsely claimed that the company earned no money and made no distributions in 2015 and 2016. You might be asking, who is Tarantino? Well, Tarantino is the accountant was the accountant for Todd and Chrisley's company, a loan out company. And I will be explaining more of him as I go along in this broadcast. Okay, just bear with me. Okay, here you have it. This is a copy of the indictment that led to their trial, that led to their arrest, that led to them being convicted and sentenced and now serving time in jail. So let's get into some of the things that were stated in this indictment, okay? Okay, at paragraph 18 of the indictment, it reads, throughout the conspiracy, the conspirators submitted false documents to banks when applying for loans, including fabricated bank statements, listing inflated account balances, personal financial statements containing false information and available funds, false invoices, and false audit paperwork. For example, on or about November 5th, 2007, co-conspirator as A sent an email to a bank that copied Todd Chrisley, attaching a personal financial statement that falsely claimed Todd Chrisley had $4 million at Merrill Lynch. When the bank employee requested account statements, co-conspirator A sent Todd Chrisley a fabricated bank statement showing that Todd and Julie Chrisley had $7.76 million on deposit at Merrill Lynch. In response, Todd Chrisley told co-conspirator A, "You are a fucking genius." Similar in content. Just make it show 4 million plus. In actuality, Todd and Julie Chrisley did not have a Merrill Lynch bank account at that time. And after they later opened one in 2008, they never had more than approximately $17,000 on deposit there. As a result of the false representation like these, a number of banks issued the conspirators millions of dollars in loans, much of which Todd and Julie Chrisley, used for their own personal benefit. At paragraph 19, it states, at various points during the conspiracy, Todd Chrisley personally directed co-conspirator A to send false information to banks. For example, when one bank provided notice in April 2008 that it would not be able to renew a loan without updated financial information, Todd Chrisley instructed co-conspirator A, quote, "Please get her the financials and I will get her the rest," quote, close quote. After co-conspirator A responded, "I don't have financials on any of these. She has tax returns." Todd Chrisley wrote, open quotes, "Stop telling me this shit. Stop telling me this shit. Create them like you always have. If I don't get these, then they won't." Similar in content. They won't renew the loans. Quote, close quote. When another bank provided notice in 2008 that it needed updated financial information, co-conspirator A told Todd Chrisley that he or she needed assistance in putting the requested financials together. This prompted Todd Chrisley to write, quote, on open quotes, "Giving me an excuse as to why you cannot," similar in content, "figure this out does not move it off your plate. This is not what we discuss. Passing it back and forth is not getting the results requested. If you do not know how to do this, then find a crooked accountant to do it." Ask who her guy uses for his crooked shit. And I'm quoting these curse words. I'm literally quoting what was said in the emails, okay? Now at paragraph 20 of the indictment, it says, the conspirators continued sending false information to banks even after receiving the initial loan disbursements. At times, they did so in hopes of renewing certain loans. At other times, they did so to conceal their financial difficulties and to prevent the banks from seeking legal remedies to recoup the outstanding loan balances. For example, on August 27th, 2009, a bank representative notified Todd Chrisley and co-conspirator A that the last financial statement we have on file, that's June 2009, looks a lot like the December 31st, 2008 statement we received, and would like to show this accurately. Wait, I make a mistake. Cash, securities, and real estate are all exactly the same. We have a review coming up and would like to show this accurately. 50, that no one questions as to how these could all be exactly the same 7 months later. Todd Chrisley forwarded this message to co-conspirator A and stated, bring the securities down significantly. The bank representative further notified Todd Chrisley and co-conspirator A that we have an FDIC examination beginning on Monday, September 14th, and your file will be one they will review. Any assistance that you can provide here to update your statement would be appreciated. Now, isn't that bank so accommodating? Todd Chrisley forwarded this message to co-conspirator A and stated, this is why that personal financial statement needs to reflect what you sent Regions funds in April 2012 to a lender. Julie Chrisley forwarded a copy of a check to co-conspirator A and Todd Chrisley and instructed co-conspirator A that the post date is the only thing that needs to be changed. The attached check stated that it had posted to a bank account on February 8, 2012. Todd Chrisley then instructed co-conspirator A to make sure this is perfect before you send it to redacted, as there, my apologies, my apologies, someone calling my name. As there can be a screw up, and she looks at this stuff fairly close. Shortly thereafter, co-conspirator A emailed Todd Chrisley an altered copy of the same check, falsely showing that it had posted to the bank account on November 1st, 2011. The conspirators also used Chrisley's asset management funds to pay down outstanding bank loans or for their own personal benefit. The conspirators did, despite knowing that the company often had outstanding checks or debts that would not otherwise be covered by remaining balances in its bank account. As a result, Chrisley Asset Management began to have significant financial difficulties. Todd and Julie Chrisley filed their appeal on March 29, 2023, and it is interesting. It really is. Todd and Julie were found guilty, as we know, and Todd was sentenced to 12 years, which is to be served at Federal Prison Camp Pensacola, and his wife Julie was sentenced to 7 years and will serve her sentence at Federal Correctional Institute, Mariana. They also have to pay restitution. After the conviction, they filed several motions. And I must state, prior to the trial, they filed motion as well. But let's get into what they filed after post-conviction. They filed motions for acquittal, motions for new trial, and motions for resentencing. All those motions were denied. They appealed to the 11th court, appellate court, asking for a stay of their sentence, meaning that they will not have to be in prison while they wait for their appeal to be heard. That was denied. They appealed for bail, applied for bail pending the hearing of their appeal. That too was denied. They really want to keep them behind bars. So, in an interview, the People Entertainment TV, Alex Little of Burr Foreman LLP, the Chrisley's attorney, stated, open quotes, "The very beginning of this case, there was an unconstitutional search by the Georgia Department of Revenue. Little claimed in an interview with Entertainment Tonight, quote on open quotes, this court's already found that was unconstitutional and it should have stopped the whole case in its tracks. That didn't happen. And that's certainly one of the things we're pursuing on the appeal." And the second thing he said, open quotes, the second piece is one of the IRS officers testified about whether the Chrisley's had paid certain taxes. He continued, "That certainly, we think, affected the jury, and we believe it will be basis for a new trial." No. Fruit of the poison tree. Remember, the attorney said the court had ruled the search warrant to be unconstitutional. He said here, at the very beginning, there was an unconstitutional search by Georgia, and the court already found that was unconstitutional, the search. So if there was a search, and as a result of that search, documents, emails, financial records, whatever information was gathered as a result of that search, technically speaking, those things ought not to have been before the court in evidence. So what they're saying here is that they were, and that is one of the grounds they are appealing. Hence the reason we say fruit of the poison tree. Okay, if the base, the genesis of something is ruined, its defect, then everything that flowed from that, any search, any information you gathered, if they went and took you somewhere to show you something, everything that flowed as a result of that, what the attorney is saying, unconstitutional search that was ruled by the court, then everything is ruined. Everything is poisonous. The issue of due process. Let's get into the issue of due process. However, remember I told you they filed an appeal on March 29, 2023. And so Julie appealed. She's arguing that there was not enough evidence to prove bank fraud. And she's also appealing the sentence. Todd, he's appealing. His appeal is on the trial and post-trial errors. Okay, so trial, what happened during the trial, and post-trial, what happened after the trial errors. So while his arguments are similar to Julie's, his goes further by stating that the IRS agent's testimony was improper because it was not factual, given the circumstances as they stood when she testified. Further, F-U-R-T-H-E-R, further, spelled wrong, my apologies. The fact that the court ruled the search warrant to be unconstitutional, yet that same search warrant led to the documents and other evidence that were obtained and led to their conviction, then he's arguing that ground as well in his appeal, which raised the issue of fruit of the poison tree, as I explained earlier. So the search warrant was ruled to be unconstitutional, yet the evidence received as a result of that search warrant were before the court and led to their conviction. Motions brought before the trial started. So when Todd and his wife were charged, they brought certain motions. Let's go through those motions so you could appreciate the appeal. So the defendants, Todd Chrisley and Julie Chrisley's, together the Chrisley's defendants, brought a motion to suppress evidence seized pursuant to the search warrants for emails and electronically stored information. The Chrisley's defendants timely filed objections to the R&R to which the government did not respond. In their underlying motion, the Chrisley's defendant moved the court to suppress various electronic evidence seized pursuant to 3 search warrants. As the R&R observes, the Chrisley defendant argued that the warrants were not sufficiently particularized. The government exceeded the scope of the warrants and acted unreasonably in their search. The magistrate judge found that the language in the warrants, while somewhat broad in defining the categories of documents authorized to be seized, was sufficiently particularized, especially considering the broad and complicated nature of the evidence relevant to the case. Further, the magistrate judge found that the 2-step process which directed the email providers to initially produce the entire contents of the subject accounts for the government's review was expressly authorized by the warrants themselves, although the government could have included more restrictions throughout the warrant application, attachments regarding a date range and names of specific persons for the intended evidence. According to magistrate judge, however, these issues did not deprive the warrant of its facial validity. More notably, the Chrisley defendants have not alleged that any emails are due to be suppressed for falling outside of these suggested restrictions. Now let's get to Peter Tarantino. He's the accountant who was also a defendant along with the Todd and Julie Chrisley. He was convicted and sentenced to 3 years in prison. He filed a motion to sever. He wanted his trial to be heard separately from Todd and Julie Chrisley. And this meant he did not want to be tried along with his former employers. So this is what the court said in regards to his application. The court said, after properly setting forth the standard for when a severance is appropriate pursuant to Federal Rule of Criminal Procedure 14, the magistrate judge cites the risk of prejudice to defendant Tarantino as the primary reason supporting severance based on an email composed by one of the defendant Tarantino's co-defendants. The email referenced a desire to engage a crooked accountant, which, according to the magistrate judge, jurors may wrongly believe is the defendant Tarantino. Or alternatively, that defendant Tarantino was hired because he fits that criteria. The magistrate judge also mentions that the overall disparity of the evidence against each of the 3 defendants is at least relevant to, if not the specific basis for, his recommendation for severance, especially since defendant Tarantino is alleged to have been involved in only one of his co-defendants' 3 purported fraud schemes. Although the court acknowledges the magistrate judge's concerns, these concerns are not unique to conspiracy cases such as the matter at bar. It is often true that not all alleged co-conspirators are charged with committing the same acts or being involved in the exact same aspect of all alleged conspiracy. However, this does not change the general rule that defendants who are indicted together are usually tried together, especially in conspiracy cases. Having considered the concerns presented in this particular case, the undersigned finds that the magistrate judge, finds that they may be addressed with proper limiting instructions and make clear to jurors which evidence applies to each defendant. Not that limiting instructions will often cure any potential prejudice resulting from a joint trial. In other words, the court finds that the jury will be capable of sifting through the evidence to make an individualized determination as to each defendant. So basically what the court is saying here is that they believe that they can cure whatever prejudice that may arise from the emails where the Todd is saying he wants a crooked accountant, and then it seems as though the jury can draw an analogy and say, oh, well, you must be that crooked accountant. there the court is saying that the jury would be in a position where they can sift out and see what evidence applies to who. And so there would be no prejudice. To that end, Tarantino's motion to sever was denied, which meant that he was tried along with Todd and Julie Chrisley. So let's look at the appeal now, because in the appeal, you're dealing with three issues. The first is whether the district court abused its discretion when it refused to hold a hearing on the defendant's Giglio claims, specifically that the prosecutors knowingly presented and failed to correct false testimony from IRS Revenue Officer Betty Carter, who lied about the defendant's owing taxes for years when she knew no taxes were due. That's the first issue. Second issue, whether the defendant's Fourth Amendment rights were violated when the district court admitted volumes of excluded evidence at trial without requiring the government to prove it obtained evidence through a source independent of its unlawful search. 3. Whether the government offered sufficient evidence as to convict for tax evasion and conspiracy counts 8 and 9 when it proved only that the defendant lawfully received his acting income through a loan-out company, which is standard in the industry and did not alter or conceal his tax liability in any way. There is an extensive list of interested parties and banks including, of course, all right? Remember I explained earlier from the indictment what was happening, and I looked at from paragraph 18 to, I believe, 20, as it relates to some of the things that were happening in terms of the bank fraud, sending documents, the bank communicating to them and telling them, well, we need further information, highlighting them and letting them know that, hey, how could the information you put forward be the same as what was you gave us 9 months ago? So that's why you would have banks and a whole list of other persons as interested parties in this suit. Let's look at the testimony, that the complaint as it relates to due process, as it relates to the Giglio claim, okay? And in the end, I will explain what is the Giglio claim, okay? So I'm reading, and what I'm reading is directly from the appeal brief, okay? From Todd's appeals brief. So it says, the IRS, Betty Carter, was the first IRS investigator to testify. Her testimony was important because the government needed her testimony to establish an important aspect of Chrisley's criminal intent, the mens rea. Without intent, the crimes are not proven, since these crimes allege that the Chrisley's specifically use of loan-out company was to evade tax. So what they're talking about, why her evidence was important, because that they use with the issue of the mens rea, a criminal intent. Betty Carter testified at length on the first and second days of trial. At that time, she testified that she prepared for her testimony by examining the relevant tax payment records in the IRS internal system. Specifically, she said that she reviewed the IRS's integrated data system, which shows returns that are filed, taxes that are due payments, and are made basically the activity on the money side of the account. Purportedly, based on her review of these records, Officer Carter testified that the Chrisley failed to pay taxes for various years and still owed the IRS money for these years. For example, she said that based on her review of the records, which she claimed she completed the morning before her testimony, that Chrisley still owed taxes for 2010 and 2014. Officer Carter also testified on the cross-examination that the Chrisleys owed money for 2015 and 2016. While she could not recall the exact amount, she told defense counsel she would let them know what it was. Remember that, because that is key. That didn't happen. Officer Carter did not contact defense counsel with these alleged balances during the trial. Instead, after the government had obtained its convictions, she contacted Chrisley's accountant and admitted that the couple did not owe the IRS the money she claimed at trial that they did. It gets even more interesting. Officer Carter told the accountant that Chrisley's were current on their taxes for 2014, 2015, and 2016, but the IRS failed to apply the payments to their account. In later emails with the accountant, Officer Carter confirmed that the IRS's system showed that the Chrisley's had made payments for 2014, 2015, 2016. Not only that, but that it exceeded the amounts owed for these years. Yet, her testimony left the impression that the Chrisley still owed substantial sums to the IRS, when in fact the IRS had been failing to apply the payments that the Chrisleys previously made to their account. Further, the IRS owed Chrisley's substantial refunds, not the other way around. Imagine that. Notably, at no time during or after the trial did Officer Carter or the prosecutors attempt to correct the record on these questions. Based on Officer Carter's false testimony and the government's failure to correct it, the Chrisleys jointly raised a Giglio claim in their motion for new trial. And requested an evidentiary hearing. The government's response admitted, albeit in a footnote, that the prosecution team knew during the trial that Officer Carter's testimony was false and that they did nothing to correct it. Let me repeat that again. When the Chrisleys filed a Giglio claim in their motion for a new trial, right? They filed it because they're saying Officer Carter told their accountant, confessed to their accountant, that the taxes that she said weren't paid, they were in fact paid. And not only that, that they overpaid. And not only that, but it was the IRS system that never posted, they updated the account. So in a footnote, the government response, in a footnote, they said the prosecution team knew during the trial that Officer Carter's testimony was false and that they did not correct it. Even in the face of these admissions, and now I'm continuing to read directly from the brief, even in the face of these admissions, the district court declined to hold a hearing. It summarily denied the new trial motion in one paragraph of a brief order without stating any reasons. So what they're saying is that when they held it summarily means that without there being a trial. And in a one paragraph, the court told them what was the decision. And there wasn't any reason for that decision. 3 days after the court ruled, the Chrisleys received documents in response to a records request to the IRS that they had made many months prior. These records, internal IRS audit trails, substantiated the Chrisley's Giglio's claims and refuted the government's assertion that Officer Carter's false testimony was unintentional and that the prosecutors were unaware of the payments. Based in part on this evidence, the Chrisleys filed a motion for reconsideration. The renewed motion alleged, among other things, that the prosecutors and Officer Carter had planned to mislead the jury and the court by basing Officer Carter's testimony about the tax payment on an IRS database that they knew to be incorrect. So I ask the question, is this prosecutorial misconduct? That is not in the appellate brief. I put that in. I'm asking the question. The appellate's brief continued. Shortly after the criminal investigation began in 2018, the prosecutors at trial, AUSA Peters and Krepp, knew that the defendants had paid their tax liability for at least 2014 and 2015. They did not want the jury to know this information, so shortly before the trial, they filed a motion in limine to exclude any evidence of the payments. When the AUSA, Peter and Crep prepared the motion, they eliminate to exclude evidence of the payments. They appeared to ask one of the IRS criminal investigators to review what payments might be at issue. That agent looked at the Chrisley tax records, which contained these payments. After filing the motion, eliminate AUSA's Peters and Crep filed a notice about it with the court in these pleadings, filed a week before the testimony. The prosecutors acknowledged that they were aware that Todd and Julie Chrisley filed amended tax returns and paid off their tax liabilities after February 2018. The court denied the government's motion in limine on May 10, 2022. And as a result, AUSA Peters and Crep knew that the defendants' tax payments from 2018 to the present in the so-called post-conspiracy period would be admissible in trial and were likely to be introduced by the defendants in their case a few days later. Now, a few days later, AUSA, that's Peters and Crep, met with Officer Carter to prepare her for her testimony in trial. And during that meeting, both prosecutors and Officer Carter knew that the defendants made the necessary payments to extinguish much, if not all, of their tax liability for all tax years before trial. Consistent with their motion in limine, the AUSAs did not want to leave the jury with the impression that the defendants had paid their outstanding tax liability. Based on all of this, it appears that at some point in their trial prep conversations, the AUSA and Officer Carter discussed the facts that the IRS employee user portal, that's the EUP, failed to reflect the payments the defendants had made after 2018 and incorrectly showed outstanding tax balances. But the prosecutors and Officer Carter knew from their prior conversations and the extensive research of the Chrisley's tax records that the balances reflected in the EUP were incorrect. Nevertheless, the AUSA told Officer Cadet that she could rely upon the IRS account transcripts from the EUP rather than the other knowledge she possessed from her review. So the prosecutors told the Officer Carter, that she could rely on the information that she got from the EUP, even though they knew that it was incorrect. So the prosecutors told this IRS officer that she could rely on that information. And remember, that information showed exclusively that the payments made exceeded the balances that the EUP incorrectly claimed were due. So to be clear, this is what is in the brief. To be clear, the AUSAs told Officer Carter her testimony would be truthful and accurate so long as she testified to what the EUP database reflected regarding the untimely filed 2014, 2015, and 2016 joint returns for the Chrisley defendants. And that is what Officer Carter tried to do, testifying on cross-examination that the defendant owed taxes for at least 2014 and 2015. And she did so even though she knew that her answers were misleading. She knew from her hundreds of searches through the defendant's tax records that they had made payments in excess of what the EUP said they owed. Yet she testified that the Chrisley's owed. So let's get into this. After cross-examination by defense counsel, when Officer Carter lied about the defendant's outstanding tax liability, AUSA CREP returned to the issue in his redirect examination of her testimony. So you have examination in chief, cross-examination, and then redirect, where the prosecution gets an opportunity to clarify and clear up little discrepancies. And this is what he asked her. Now, you also said something about you checked yesterday morning, and I believe there was a back and forth about what you were checking and all of that. I want to give you an opportunity to complete your thoughts on that. And this is her response. Yes, I just went and checked on all outstanding balances and there are additional tax and penalties owed. So prosecution in his redirect asked her that there was a back and forth about what you were checking. And so he asked her to complete her thought, and her thought that she completed on the stand on the oath is, yes, I went and checked on all outstanding balances and there are additional tax and penalties owed. The prosecution said, to this day, meaning the day at trial, and she said yes. She said yes. Under oath, she said she checked the system, and on the system, it is saying that they owed. No. Prosecution is telling her it's the truth. Because, and when you think about it, if on the system it is showing that Todd and Julie Chrisley still owe taxes, the system is saying that. So her saying the system is saying that they owed, yeah, it's true. The system is reflecting that. But they also knew the reason why the system was reflecting that. They knew not only that the system reflects this, but we also know that they already paid though. So while she clarified and said when she checked the system, it showed that they still owed additional tax and penalties are still owing, she never bothered to say, but we know the system, there is a delay, or the system is behind time because they have made this payment. So they relied on what is really on the system and not clarify to the jury that the system has this, however, they already made the payments. And the prosecutors told them that that is the truth. And when you think about it, if you're talking about simply what is on the system, yeah, it's the truth. But there is room for clarification because while that is the truth, what is on the system, there is a defect with the system. The system has a defect. The EUP system has a defect. It's not reflecting that they already made the payment. Continue. This is, and again, directly from the brief. This testimony was intentionally misleading. This is what Todd Chrisley's attorney is saying in his brief for the appeal. This testimony was intentionally misleading as detailed above. And both AUSA CREP and Officer Carter knew that it was. This testimony was intended to reinforce the false testimony that Officer Carter had provided the day before during cross-examination about the 2014 and 2015 tax years. It was also false because Officer Carter had not checked on all outstanding balances as she claimed. The AUSA CREP's motive for returning to the issue and asking the question on redirect was clear. He wanted to undermine any argument that the defendants might have had about demonstrating their lack of intent by showing that they had fully paid their tax obligations. So I asked the question, I see it as a crucial question. When did the Chrisley pay their taxes? And I think that is key. You would want to know, well, when did they pay? Okay, the system is reflecting that they owed, but we know that they came in and paid, and the system has a defect because it's not showing real time what is owing, if anything at all. But I think curiously you would want to know then, when did they pay this money? Did they pay after the grand jury? Did they pay after the search? So it's interesting, but I haven't come across that as yet. So when the defendants presented evidence of the tax payments in their case, which began on June 1st, 2022, AUSA's Peters and Krepp did not contest it because they knew the defendants had made the payments at issue. We know this not only from their conversations with Officer Carter and her MOI, as documented, above, but also because Agent Kinsler called the prosecutors on the morning of June 1st, 2022 to raise the issue again. At no time during the trial, even after Agent Kinsler flagged the issue for them, did the AUSA comply with their Giglio obligations and notify the court about Officer Carter's testimony or attempt to correct it. In a footnote, it says that although AUSA's Peters and Krepp claim to have forgotten Agent Kinsler's call, this assertion is believed by the fact that Kinsler was telling them about the very aspect of Officer Carter's disputed testimony, and the defense witness, Bill Salinsky, was scheduled to testify about and did testify about that very same day. So what they're saying here is the prosecutors knew that there was a glitch in the system, that the system, there was a delay. The prosecutors knew that the Chrisley had already made the payments. Not only that they knew from Carter, Officer Carter, but they would have known from Kinsley, who called them that very morning and brought that issue again. But they said they don't recall the call. Don't recall the call. Funny. More than a month after losing jurisdiction over the substantive issue in this appeal, the district court issued a 78-page order to set forth the reasoning and analysis for its decision to deny all post-trial motions nearly 3 months prior. So remember we talked about the post-trial motions that Todd Chrisley and Julie Chrisley filed? Well, and remember the court made a decision and never gave any reasoning. Well, what they're saying here is that 3 months after, they made reasoning. But bear in mind this, that they had already filed the appeal. And so what they're saying is that the district court no longer had jurisdiction because they appealed the matter to the appellate court. So the order did not address the district court's jurisdiction or grounds for issuing a substantive decision while this appeal was pending. Instead of stating for the reason described in the order, the trial was adhering to the ruling set forth in the prior order. On its own terms, now let's get into this part. The district court's order contained multiple factual errors. As an initial matter in the order, the court found that the Chrisley's owed taxes that even the government did not claim were due. Imagine. So the court took in consideration extraneous matters that were not before it, because it's saying the court found that the Chrisley's owed taxes that even the government did not claim were due. The government had acknowledged that much of the Officer Carter's testimony about the taxes was mistaken, and its sole written response to the new trial motion did not assert that the Chrisley's really owed taxes for 2009 through 2016. It made other arguments instead. At the footnote number 4, it said that the government did claim that the Chrisley's still owed a residual balance from 2016, but the Chrisley's dispute this claim. Against this backdrop now, the trial court's findings were head scratching or wig scratching. It concluded that the Chrisley owed taxes for 2010, 2011, and 2016, and that they might even owe for 2014 and 2015. It reached these conclusions not based off the parties' arguments, but only because Officer Carter's affidavit said that she provided payoff amounts to the Chrisley's accountant after trial, and that their accountant sent checks for those amounts. The court assumed, despite witness statements and arguments to the contrary, that these post-trial payments amounted to an admission that money was owed. They did not. The post-trial payments were meant to help the IRS clean up existing balances in their system so that the Chrisley's outstanding tax credit could be applied to the larger sum going forward. This is why Officer Carter's affidavit references outstanding credit balances. This is why Officer Carter's affidavit references outstanding credit balances. Fictitious. The district court speculation is even more confounding because its order also acknowledges elsewhere that Officer Carter's testimony about the 2014 and 2015 tax owing was false. In other places, it concluded her testimony was an unintentional error. In doing so, the court assumed that Officer Carter's testimony was reasonably based on information she accessed via the IRS's internal EUP system. The court did not explain why it disregarded defendant's expert affidavit that the IRS audit trail showed that Officer Carter knew the payments have been made contrary to what anything in this system might have said. Using this example showed the district court simply assumed the government's witness was right and that the Chrisley's accountant was wrong. Even more bizarre, the court speculated that the Chrisley's may have owed taxes for 2014 and 2015. Again, this is not a theory the government ever advanced. For those years, the government admitted that the Chrisley paid the balances due for 2014 and 2015, but claimed that the IRS database did not recognize the payments. How conveniently, right? Yet, even in the face of this admission, the court theorized that even if the Chrisley defendants had zero balance for the tax year of 2014 and 2015, at times prior to May 2022, this does not necessarily mean that their balance were zero as of May 2022 when the trial occurred. What this appears to mean is that though the Chrisleys paid off their taxes for 2014 and 2015 before the trial, there is no argument that they owe them now. The district court believed it was possible that they might have owed them during the small window of time when the trial took place, which would have made Officer Carter's testimony true. There is zero evidence in the record to support the court's conjecture. On appeal, this court reviews the district court's denial of new trial motion asserting a Giglio claim for abuse of discretion. The same standard applies to the question whether the district court erred by denying the motion without first conducting an evidentiary hearing. So for those of you who might be asking, what is a Giglio claim? Okay, so here it says a Giglio and the United States is a United States Supreme Court case in which the court held that the prosecution's failure to inform the jury that a witness had been promised not to be prosecuted in exchange for his testimony was a failure to fulfill the duty to presenting all material evidence to the jury and constituted a violation of due process, requiring a new trial. And this is the case even if failure to disclose was a matter of negligence and not intent. The case extended the court's holding in Brady and Maryland, requiring such agreements to be disclosed to defense counsel. As a result of this case, the term Giglio material is sometimes used to refer to any information pertaining to deals that witnesses in a criminal case may have entered into with the government. And further information is the Supreme Court began its analysis by noting that deliberately deceiving the trial court and jury by presenting evidence known to be false and had held to be incompatible with the rudimentary demands of justice as early as Mooney and Holohan, the Neptune, the court had held that the same result occurs when the state, although not soliciting false evidence, allows it to go uncorrected when it appears. In Brady, the Supreme Court had held that irrespective of the good faith or bad faith of the prosecution, suppression of material, exculpatory evidence required a new trial. So, I know that is a lot. And there's more that I need to get into because I remember I told you there's 3 issues. It is a lot. But it's enough for you all to look at it and think about it, what transpired in this trial. No, it's not saying the bank fraud. We're not there yet to the bank fraud, because remember, the bank fraud, all that evidence came from fruit of the poison tree, and this is the arguments being made by the attorneys for Todd and Julie Chrisley. All right, they're saying that the search warrant was already deemed to be unconstitutional. Now, what aspect of the search warrant, I would need to get into that. And then now we're seeing the motion for a new trial and the reason why, and they're bringing it under the Giglio. And I just explained what Giglio is. Due process. So I ask a question. In this case, was there prosecutorial misconduct? I don't know. It will only, you have to go through it and wait to see what the appellate court will decide. Did the prosecutors lie when they told Officer Carter, report on what is on the system, and that is the truth? Even though knowing the system had a flaw, that it wasn't reflecting that payments were made, and not informing the court nor the jury of that, and making it seem to the jury that these people still owe taxes and penalties, when in actuality they didn't. Let's wait and see what will happen in this appeal. Until then, Get Legit LLC, thank you all for joining me. I hope you all enjoyed this recap, this reading. It was a lot. I know it was a lot. But let me hear what you have to say in the comment. Let's discuss it. Okay? Thank you. And thank you to all my